Hi, my name is Goldman. I'm attorney Goldman Associates, and today I'd like to address the issue of what happens when the father's name is not on the birth certificate. In the context of a marriage, there is a presumption that the parents share equally in the custody of the child. So even in that scenario, if the father's name is not on the birth certificate, it's still considered a child of the marriage. As a matter of fact, if those parties were going to get divorced, they'd have to have special provision in the judgment of divorce explaining that a child was born, he's not on the birth certificate, it's still a child of the marriage, and if it turns out that that child was actually not a product of the marriage, the judgment would have to explain why that child is not a product of the marriage. Why? Because the presumption assumes that he is. There's a presumption in favor of the paternity in a marriage. However, in a scenario where it's a non-marital union, if the father's name isn't on the birth certificate, there's no presumption that just because he was in a relationship that he's the father. Therefore, if you want to assert your rights as the father and your name is not on the birth certificate, you're going to have to file a DP case, a petition to determine paternity. When that is filed, what essentially the court does is after everybody's served, the court enters an order requiring DNA testing. And then it's sent out to a court-approved lab, and ultimately the court will determine, based on those results, whether or not that person filing that case is in fact the father. If he is, then the various rights and liabilities will attach. If he's not, then no rights and liabilities will attach. And that's how that is handled. If you have any questions about that, of course, reach out to us and we'll be glad to help you out. If you found this helpful, please like and share.